Hi, good afternoon, everyone. Good afternoon. Thank you for patiently waiting. My name is Rachel Gutierrez. I am with the City of Houston Department of Neighborhoods, Office of Neighborhood Engagement. I'm a community outreach coordinator for the department. We welcome you to a monthly service program. We took a break for the month of July, and so that went by quickly. And back here providing you with information that we would normally do, but we needed to take a break, all of our partners, to be able to recalibrate. So we're thankful for that break, but now it's back to business again. So thank you for joining in, and we are excited to continue providing you with the information that we're able to provide you with. A little history of a month of service. All of our partners separately were doing the work individually, and so we were saying, this is a great opportunity to join forces and to allow us to provide you the information in one setting so that you're not going here, there, everywhere to be able to obtain important information that may be beneficial to your everyday lives. So within our partnership is Neighborhood Recovery Community Development Corporation, the Harris County Tax Assessor Collector's Office, Earl Carl Institute, the Houston Bar Association, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, Lone Star Legal Aid, and as I mentioned, the City of Houston Department of Neighborhood. So we do want to be able to provide you the information in one platform. So we're thankful that we're able to do this. One thing about our platform is that we're offering this information for educational purposes only. This is not legal advice or legal services. So I just want to stress that. Also, when we're talking or answering questions that you may be able to do so, please make sure that you try to be as general as possible. Don't give out any personal information such as addresses, social security numbers, things like that, because this is a recorded meeting. We are streaming live as well. We don't want anybody to be able to have access to your personal information. Just be as general as we possibly can. However, if you do need additional assistance with questions that cannot be answered through this platform, you are more than welcome to follow up with any of our partners during any of our topics to do one-on-one advising, or if that's something that you probably need legal representation or what have you, you can do that off camera. But we do want to thank you again for joining in, and also mention there are several topics that we offer throughout the month, every month. And so please continue to tuning in to take a part of those different topics. We believe in preserving generational wealth, about financial literacy, education on just home ownership in general. So if there isn't a topic that we do not currently offer, but you are interested in having or obtaining, please feel free to reach out to myself. I'll put my information in the chat, and also I'll give it out at the end to those that are not in the actual Zoom but streaming live, so that you'll be able to have it. Or you can also reach out to Neighborhood Recovery to put those suggestions in. Please keep continuing to our faithful list watchers. Please continue to promote our services out there, because the more people we are able to engage, the more services that we are able to provide, workshops and things of that nature. So, if it might not affect you, but it might affect somebody that you know, whether it's at church, whether it's at your community centers, your gyms, your grocery stores, your local neighbor. I'm sure something that we have as far as topics can benefit them or yourself. So without further ado, I do want to present our presenter for today. Today's topic of wills and advanced legal planning, and why do you need it? She is from Lone Star Legal Aid. And also I do want to mention if after this you are interested in seeing if you qualify to receive a free or low cost will, I will also provide you with that information so you can so we can receive your information and refer it to Lone Star Legal Aid or any of our other agencies to see if you are able to qualify for a free will. Where can you go to sign, wills, lawyers and things like that? It's very, very costly, or it can be. So there's opportunity for you to be able to get your estate planning done for you. So that information will be provided at the end of the workshop as well. But without further ado, Ms. Safna.
Hi, everybody. Thank you for having us. Like Rachel said, my name is Safna and I'm with Lone Star Legal Aid. Let me share my screen. Okay. I am not Jessie Campbell. Jessie was unable to join us today, so I am covering for her. My name is Safna Iyer. I'm a directing attorney in our Houston office, and I work very closely with Jessie, who is also housed in the Houston office. So like Rachel already said, I do want to repeat that this is an educational presentation, excuse me. This is not legal advice, and nothing in this presentation creates an attorney-lawyer relationship of any kind. So we are a nonprofit. Our service area includes 72 counties along the eastern and Gulf Coast regions of Texas and a couple of counties in Southwest Arkansas. We have 14 offices, including the Houston office. We are an income and asset-based program, so in order for us to represent you or work with you, you do have to qualify for us. We handle a wide assortment of civil law matters, including consumer and employment, healthcare, housing, family law, landlord and tenant, neighborhood problems, estate planning, which is what we're going to talk about today. And down at the very bottom of this slide is our webpage as well as our phone number. You can apply with us by calling that phone number, or you can actually apply with us online on our website. So today's presentation is a very basic conversation about advanced planning, meaning how to plan for what happens to your stuff after you pass away. So advanced planning is preparing for a couple of different things. It's death, which I think is what most people think about. It's also incapacity. It's care of minors or adults who are disabled. And it's long-term care. So the point of this is to kind of determine who is going to be in charge and putting it into a document that is legally binding. Probate is the process of handling your estate after somebody passes away. And it's filing an application in court with an attorney, it's paying off debts, it's transferring property ownership. It can also include managing issues for individuals with that have legal needs after somebody passes. So what happens in the court process depends a large part on what was done to plan for the event of death. Okay, so when you're developing an individual plan, there's several factors that you really need to think about. Family members and dynamics. So who is your family? Are you married? Do you have children? Are you single? Are you divorced? Do you have adopted children? Do you have parents that are still alive? Or are you never married and you have brothers, sisters, uncles, aunts, nieces? All of those kinds of things are going to determine how you're going to plan for your estate to pass on after you die. It also depends on the type of property that you own. There are different ways that you can transfer different types of property. Who is going to inherit? Do they have needs that have to be taken into consideration? For example, are you leaving something to someone who's a child? If you died tomorrow and the person you're leaving your estate to is 12, there are things that have to be taken into consideration. Are Are there special needs? For example, you are passing your estate on to someone who's an adult, but that person happens to be disabled. So those are the kinds of things that you have to talk about. What is your current health condition? Are you going to have to plan for what your health might look like? Is there a chance that your health is such that you could become incapacitated later? So those are things that you need to consider when you're looking at an individual plan for yourself. So let's suppose you have documents already. When should you update them? And the answer is you update them whenever you have a major life change. So marital status, were you married when you created the documents and now you're not? Do you have children? If you didn't have children before and you have children now, do you want them in your will? Are there any health changes? Were you healthy when you wrote your will and maybe you're not now? Maybe you need to rearrange where your finances and where your estate is going to go to take care of your own needs versus what your state of health was when you actually wrote the documents. And have there been major property changes? Did you list one home in a will and now you no longer own that home? Now you have a different home. So those are things that you need to think about. Choose your representative. So your representative is the person that is basically going to do what you would want them to do in the event that they are called upon. You need to be careful when you're picking your representative because it's not uncommon for there to be strife, for there to be arguments about what property is going to go where or how mom and dad would have wanted to be buried, what mom and dad would want done with their remains, right? Where they would want the house to go. If you have a will, that's first of all why you need a will, but you also need someone that's going to do what you want them to do. So you're going to select someone that you know and trust, and that will do what's in your best interest. You only want there to be one person. You don't want 3 decision makers. You're going to discuss the decision with the person, and you need to have an alternate. So this also will come up because someone always has to do something after you die. You always have something that has to be handled, whether it's your remains, whether it's planning for the funeral, whether it's an estate of some sort. It might just be a car, it might just be a house, it might be a combination of things. So if you come away with nothing else from this presentation, you need a will, you need a durable power of attorney, and you need a medical power of attorney, okay? And just as a side note, there are some state of Texas approved forms for very, very, very basic, very simple wills. They are on the Texas Supreme Court website. So these are examples of someone who has a will, who's never been married, has no children, and they need a will to dispose of their own property. There are very simple forms there. So if you have a very simple estate, the number of people that you're going to be leaving things to, you can check out those forms at the Texas Supreme Court website. Okay, understanding property and transfer of ownership. Everybody has personal property. Personal property is everything that's not your home. So it could be a car, it's clothing. Your clothing is personal property. It's furniture, it's jewelry, anything like that. So you might not have much personal property, but everybody has something. Somebody has to have the authority to decide where that property goes. And they need instructions on what's going to happen and who gets it and where it goes. So that's why you need a will. That's why you also need somebody that you can trust and that will do what you want them to do regarding your estate. And again, do what you want them to do and be able to withstand all of the people that say, well, that's not what they would want, or that's not fair, or they changed their mind, or I can't believe they really wanted that. You need someone that's going to hold fast to what you want done. Titled property, so that is almost always your home, right? You have a deed, your name is on it, you are on the title. Has to go through a legal process to transfer title clearly to that property. Verbal agreements are not enforceable, okay? So you cannot show up in probate court and say, but mom said I could have the house. That's not going to hold up. you need something in writing. And importantly, a co-owner of a property doesn't necessarily get all of the property if the other co-owner dies. Now, that might be the case in Texas, but it doesn't always have to be the case in Texas, depending on how complicated your marital history is, depending on if you have children, depending on if you adopted children, depending on when you bought the house and when you bought when you got married. There are all sorts of factors that go into ownership of a property when someone passes away in Texas. Last will and testament. So I think everybody knows what this is. The will is your legal document, which the person that you appoint, again, this is your representative, the testator. No, I'm sorry. When would you, the testator, write down what you want to happen to your property and your debt? Your debt is included in the estate after their death and who they want to manage the estate. And that person is the executor. It's only going to cover things that pass through in probate. And probate is the probate court where you are going to go, you're going to present the will to the probate judge, and the will is going to get probated. Non-probate assets. So there are mechanisms to transfer property in Texas so that they do not have to go through probate. They do not have to go through court. If you have a retirement account, this is your IRA, this is your 401k, this is your 403b, you can designate a beneficiary. So you put in that paperwork who you want to get the money if you pass. So it can be anybody you want. It can be your spouse, it can be your kid, it can be your brother, it can be your uncle. But if you have someone designated on that paperwork in that account, when you pass, that money will go to them without having to go through probate court. Life insurance proceeds payable on death accounts, those are the same situations. There are forms that you will sign, that you will fill out, where you will say, when I pass, this is where that money goes. Joint tenancy with right of survivorship is a way that you can transfer property in Texas so that when one person dies, it automatically goes to the survivor. So if you and your roommate, for example, buy a home together, right? Homes are expensive. You chip in your money, you realize that, hey, we can pitch in, we can buy a house together, but we're just going to share it as housemates, right? You own your half, I own my half. You can do a joint tenancy with right of survivorship so that when one of you dies, the other person gets the entire title to the house. But that is a specific type of title document, and the title document has to be crystal clear that that is what you are creating. Everything else is a probate asset and needs to go through probate. If you don't designate somebody for the accounts that we just talked about, then your estate is the beneficiary, and your estate is everything that you own and the debts that you own at the time that you died. Transfer on death documents. So you can use transfer on death documents in 2 instances in Texas to transfer title without going through probate, but the title transfers when you die. What we talked about before right here, this isn't about title. This is about who gets the money when you pass away. This right here, these are about title. So you can do what's called a transfer on death deed for your home, where you actually sign a document. It's called a transfer on death deed. It is a deed. It's exactly what it sounds like. And you can say, when I pass away, I want my daughter, my husband, my cousin, my best friend, whoever you want to get the home. If you execute a transfer on death deed and do everything that needs to be done, needs to be notarized, it needs to have the property description, it has to be filed with real property records, then that essentially pulls the house out of probate. And when you pass, the house will go to whoever you says it will go to. Vehicles. There is a form that you can pull off the DMV, and it's a beneficiary designation. So when you pass, again, the title to the car goes automatically to that person that you say. While you are alive, you can still do whatever you want to those properties, but If you still own those properties and you have completely and accurately filled out these documents, when you die, the property transfers to whoever you say is going to get the property. And again, this will take priority over a will. So be careful. It's not ideal in all situations. You want to make sure that you know what you're doing. You can change your transfer on death deed if you want to. You have to, again, file complete and accurate paperwork to completely revoke the first one and file a second one, or just revoke the first one completely, which then pulls it into the estate. Debt survives. So even though you might be dead, the money that you borrowed, the money that you owe, did not die. It will go into your estate. And so your estate is responsible for paying off the debt at the time that you die. And I want to say your estate, and it's not your heirs. So the estate is your property. It's your home. It's your car. It's your furniture. It's any jewelry. If you have debt, the court can order things to be sold to pay off those debts. When you inherit property, if you have a mortgage, you inherit the home with the mortgage. So you are responsible for paying the mortgage. You're responsible for paying any taxes that might be owed on that house. If you have if your parents had a reverse mortgage, right, you have to be 62, I believe, or 65, but you have to be in your 60s to get a reverse mortgage. When that person passes, whoever inherits the home only has 6 months to pay off that money before the reverse mortgage company can begin foreclosure. The 6-month period is either for the estate to come up with enough money to pay off the debt, or for the person who inherited the home to pay off the debt, or to be able to refinance the loan into a loan that's in their name with payments that they can afford. It is extremely common. Reverse mortgage companies can and will foreclose when they find out that the older person that took out the loan has passed away. So your durable power of attorney, they are able to make legal and financial decisions for you. You can decide if it's immediate or it's when there is some kind of incapacity. And you can also have one just for safekeeping, for backup. So for example, I am power of attorney for my parents. Thankfully, right now, we don't need it. But if something happens, I have the legal document to be able to make those decisions. Medical power of attorney. You are going to want to name somebody who can make a medical decision for you if you are not able to do so. And it is only effective at the time of incapacity. I also have a medical power of attorney. So you need to decide, there are choices to make, right? Do you want to have a do not resuscitate? Do you want to be hooked to life support? How long do you want those things to happen, right? Do you want to be on a ventilator? Those are all things that you need to decide, and then you need to designate someone with a medical power of attorney that will specifically lay out, this is what I have agreed to, this is what I have not agreed to. And again, if you have a medical power of attorney and your life changes, you need to create a new one and specifically revoke the other one, right? You don't want competing medical powers of attorney out there. So, but this is a really important document to have. If you have any medical issues coming up, if you're going into surgery, even if it's something completely minor, you need to have someone who is able to make decisions for you if you are unable to make them yourself. There are a bunch of advanced planning documents. Disposition of remains. So how do you want your funeral to look? What do you want to happen to your body after you die? Do you want to be an organ donor? Do you want to donate your body to science? Do you want to be cremated? Do you want to be buried? Are there any cultural applications or considerations to think about? Those are things that you want to decide, and your person who's responsible for that with the disposition of remains document, that stuff is laid out. Do you have a supported decision-making document? This is just someone who's got diminished capacity. That doesn't mean that they can't make any decisions, but they need someone to help them. A guardian in the event of incapacity. So if you become incapacitated, is there somebody that you trust to look out for you and make decisions while you're still alive? A HIPAA release. So this is about medical records, right? The HIPAA laws protect privacy. They protect all of your data. So who do you want to be able to have your documents? Who is the doctor allowed to talk to? Who is the hospital allowed to talk to? Advance directive to physicians. So again, this is what we talked about a minute ago. If you have a terminal or irreversible medical condition, what kind of medical treatment do you want? Do you want to be hooked up to a ventilator? Do you want there to be life attempting measures in the event that you have brain death, right? Like those are all things that you need to think about and decide for yourself so you can create this document that says, this is what I want, this is what I don't. And a declaration for mental health treatment. So someone to make decisions for you if you're not going to be being admitted to psychiatric hospitalization. Long-term care planning. So this is exactly what it sounds like. You are looking ahead at your own medical health, your own well-being, and you are trying to plan for what you think may or may not happen, right? So this is where you're going to pull out your crystal ball and you're going to look at your future and you're going to see what you're going to need to plan for. So some of this is a little bit easier, right? As we age, we all have issues and aches and pains. Some of this is harder because you don't know what's going to happen, of course, right? And it depends on the kind of planning that you have done up until now. So if you are going to be required to rely on Medicaid, there is a Medicaid estate recovery program, meaning when you pass, depending on the number of assets you have, Medicaid will come after your estate to recover money they have spent for you. You can plan for that with what is called a qualified income trust. It's a Miller trust. It allows you to put a certain amount of money aside, basically, and Medicaid doesn't count that against your asset limits. You can do an advanced life estate or a transfer on death deed. They are very, very similar. Transfer on death deed is a newer statutory creation. Enhanced life estate, ladybird deeds have been around for quite a while. There are some differences, but more or less they accomplish the same thing. If you are talking about these things, if you're thinking about these things, you should discuss with an attorney. So when you're doing your planning for any kind of appointment, these are the things that you need to think about. You need to create a list of your bank accounts. How many bank accounts do you have? How many retirement accounts do you have? Where does your money go? Do you have investment accounts? Do you have a Roth IRA? Do you have safety deposit boxes? Do you have accounts that nobody else knows about and that nobody else would even think about knowing about if you didn't write them down somewhere? Do you have Bitcoin somewhere in some sort of virtual net wallet? Be sure that your executor can access any digital assets. And then keep all of your documents in a safe place. Put them in a safety deposit box. This is one of those things that you can put down someone who has the authority to enter the box in your will. Another option for this is when you create your box, you can add someone on it as a co-renter. So they have the option to also access the box. Depending on the attorney that you use, sometimes they will store the documents for you. Sometimes they will be the representative for you. There is, of course, extra fees for all of that. So it's be something that you need to discuss with any attorney that you use. And then discuss the documents with your representative and your family. So for my family, my parents have created their will, it's updated, and the 3 adult children, me and my brothers, all have a copy of their will. Okay, that's it. Let me see if there's any questions here.
Let's see here. There's not any in the, I don't see any so far in the chat, but if you do have a question, feel free to unmute yourself or raise your hand so that we can recognize you for the question. Deanna, do we have any, I know you have access to the live stream. Are there any there in the in the live stream?
I don't see any question. But let me check on the social media.
Okay.
Mm, mm, no, no, I don't see any comment.
Okay. Okay. Well, certainly we want to stress the importance of estate planning. I know a lot of individuals think that estate planning is something that you do older in life, but you know, we always want to stress the importance of as long as you're 18 and up, there's something that it's very important for you to be able to settle your affairs because unfortunately at any given moment something can happen. It's not the taboo of, you know, waiting until you're older to get your affairs order. It's something that we have to step away from and ensure that, you know, people in their early 20s, people in their 30s need to sort out their affairs because unfortunately at any given moment something again can happen. It's also important to take away the stigma of, you know, or, you know, educate others as how much of a hassle and headache it is of going through the process, and people that are unaware of what the process takes of dealing with the courts and dealing with the state when there is no heir. It's a long, arduous process. And to help avoid or help minimize that, you know, having an estate plan set in stone will help with, you know, they already have to unfortunately grieve their loved one. And so, you know, having their affairs sorted out can help ease that a task when you're already grieving to try to sort things out. So very important to have to get this done. You can do it at any age again. And for those that are interested in seeing if you qualify for an estate plan, you can definitely reach out to Lone Star Legal Aid directly. I put a flyer in the chat. If you want to do a pre-assessment through the city of Houston, you're more than welcome to do so. And we'll get you over to the right to one of our partners for you to be able to do so. Along with the estate planning, we will also be hosting an in-person a workshop that will be next month. If you're, you know, wanting to come in person on September the 5th, we'll have that. But at Sunnyside Multi-Service Center, along with, and obviously you can ask more in-depth questions. You can get one-on-one assistance there with our partners that will be there. Lone Star Legal Aid will be there, and as well as our other partners. So you're more than welcome to do that as well. For the A Month of Service program, we have several workshops again throughout this month. You can go to the website to register for any of the workshops. The next coming workshop is on Tuesday, and it covers what is a pro bono attorney. There is a difference obviously between pro bono and you know, in their services and what they offer versus an attorney that has their law firm that they charge and do all that spiel. So we'll cover what are the advantages and what are the limitations or restrictions or whatnot, or what they can do. So if you want to learn about the pro bono attorney, that's on this upcoming Tuesday, August 6th at 1 p.m. And the rest of our schedule again is on the NRCDC website. As far as for me, my contact information for those that are live streaming, phone number is 832-393-0887. Again, 832-393-0887. I put the information also in the chat. My email address is my first and last name, rachel.gutierrez@houstontx.gov. Again, rachel.gutierrez at houstontx.gov. So let me see here. If anyone doesn't have a question, we can go ahead and give you back the rest of your afternoon. But thank you once again for tuning in. We truly appreciate your participation, and we look forward to seeing you on Tuesday. Thank you so much, Sapna from Lone Star Legal Aid. We appreciate everything you guys do.
Thank you for having us.
Good evening. Bye-bye now.